Good morning, everyone. My name is Kasar, today's host. So let's start this session along with a wonderful guest and all my dear students. First of all, I want to tell that this whole session is based on IPR, which is intellectual property rights. So I would like to give a general introduction about IPR before we start. Intellectual property rights are the rights given to the person over the creation of their minds. They usually give the creators an exclusive right over the use of his/her creation for a certain period of time. It provides income and cause movement of all kinds of resources, and and therefore creates industry and commerce. The intellectual property has a very important role in both economic and social development of mankind. Intellectual property right has economic value like any other property. So all these things, then I would like to welcome our today's wonderful guest, Mr. Abhishek Singhal, sir, Director of Singhal Consultancy and also intellectual property attorney. He specialized in the registration and maintenance of patent, design, trademark, and copyright. He helped organizations and individuals to develop patent portfolio strategies for exciting new inventions and processes. So, on next note, I would like to hand over this platform to our guest, Mr. Abhishek sir, to enlighten us with a motivational thought. Abhishek sir,
Uh,
are you there?
yes.
Yes, sir. Please continue. Now, platform is yours.
First of all, I would like to thank IMT College of Pharmacy, who has given me this opportunity to share my views and to conduct this session on IPR and problem solving and ideation. Today, we're gonna cover about what exactly the intellectual properties are, the types of intellectual property, and how the processes arises from a problem solving and ideation through the various steps that we can opt while developing the technology. First, we'll understand what is intellectual property. Intellectual property is a property or a category of a property that is generated from a human intellect. Means if we have think something creative, a new thing has been created via our mind, then that property is known as intellectual property. Such properties are? Such properties are known as invention, literary work, literary and artistic works, designs and symbols, names and images, and further, we have to understand these are the intellectual properties that we have generated. But how we can protect these intellectual properties? These intellectual properties are protected through the various laws that we have in the country, such as patents law, the trademark law, copyright law, etc. These are the different types of laws that different kind of intellectual property is protected under that particular law. Further, intellectual property helps in enabling people to earn recognition or financial benefits from what they have created or invented. Now, we have understood what the intellectual property is. And once we understand the intellectual property, then we can easily understand what the intellectual property rights are. Secondly, we'll be moving towards what intellectual property rights are. The intellectual property rights are the legal rights given to a person or a creator to protect his intellectual property. And we understand these rights are the legal rights given by the authority or a government of Indian authority who give us those rights for our creation of the intellectual property that we have created. IPR are the exclusive rights that are given to a person or a creator in lieu of that property. It means these rights are exclusive, means nobody has the access to get these rights. I am the only exclusive person, and I will be the only person who will be using those rights because I am the creator of that intellectual property. Further, a IP, intellectual property, provides a person or a creator an exclusive rights to his use, or to use his her creation for a certain period of time. Now we have understood it is a time bound, means we have the intellectual property rights for some times, means we have a certain period that has been defined in the laws, and according to that those rights are protected for that particular period, and different intellectual property has the different time limit. uh, and we're gonna covering that in our next slides. Now we're gonna understand what are the different types of intellectual properties. We always tell we have generated these intellectual properties. What are these exactly? Because these the definition or the intellectual properties that we have created has the some advantages and disadvantages, and a different intellectual properties has a different capacity of protection, such as the different properties are the patents. Patents is also one of the kind of intellectual property. The design that we have created from our mind, the brand name or a symbol or a logo or the slogan that we use in our day-to-day life, that thing is protected under the trademark. And the copyright means if we have written any book, poem, or any a videography or any filming is there, then that is protected under the copyright. And trade secrets are the information that are secrets by the company. It means the company has generated secrets to establish in the market, and uses the different processes that he don't want to disclose in the open market, and that things can go in the trade secrets. But in India we don't has a specific trade secret law. We have a different supporting laws to protect our trade secrets. And one is the geographical indication. It is a type, it is also another type of intellectual property that has given to any location. Just example, the Darjeeling tea or the Kangra tea, and we'll be covering each intellectual property in details so that we get understand what exactly the intellectual property is and how we can define those intellectual property and choose our path to protect those intellectual property in that particular domain. And there is a semiconductor chips are there, which are also protected under the Semiconductor and Design Layout Act. And if there are seeds, plants, and then that are protected under the Plant Variety Act. Now I think you have understood the different types of intellectual properties are. Now we'll be starting with the patents. A patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. A patented invention cannot be commercially made, distributed, import, or sold by others without the patent's owner's consent. Patents are the territorial rights in nature and applicable in the country or region in which a patent has been filed or granted. The, the protection is granted for a limited period, generally 20 years from the filing date of the application. Now we have understood that what are patents. It is generally exclusive right for our invention or the innovation that we have done in our day-to-day life, or while working we have invented something, then it is considered as an invention. And it can be it gives me the person who's the patent owner gives that exclusive rights. Means if I have a patent, then I can be the only person who can commercially made use those articles, distribute those articles, import those articles, or sold those articles. Without my consent, nobody can use these patented article, or they cannot sell the. I can use the patented article because I have sell that, I have purchased that, but I cannot remade those patented articles. Further, we have to also understand the patents rights are the territorial in nature. Means if we file any patent in India, then it is then we have received a patent under the Indian patent law. Means our rights will be the territory will be applicable in the territory of the India, not in the territory of US. If we have to protect those patents in USA, then we have to file a patent application. Then only our rights get secured, and the patent is granted according to the US patent laws, and it won't be according to the Indian patent law. And there will be the difference in different patents laws, and they have a different criteria of giving the patent. So that's why it is applicable according to the territory in which we have applied for. But the patent limit to use the patent is 20 years. And once the 20 years got expired, then everybody and anybody is free to use that particular patent, and they can sell those goods, they can import those goods easily. I think now you have understood what exactly the patent is, what how I can commercially use it, and where I get the patent rights, and what is the limitation of the patent right, where means the 20 years. Now we're gonna covering about the industrial design. Industrial design constitutes a ornamental aspect of an article. An article design may consist of three-dimensional features such as the shape of an article, or a two-dimensional features such as a pattern, lines, or color. Prevent third parties. If I had a design registration, I can prevent third parties from making, selling, or importing articles. In most countries, we understand that the industrial design needs to be registered in order to be protected under the industrial design law as a registered design. In some countries, industrial design are protected under the patent law as design patents. The protection is granted for a limited period, generally 10 years from the filing date of the application, and further extended to 5 years after paying the official fees. Now, we're gonna uncover all these points and understand what exactly the article is. I have taken an example of a pen. We all understand that pen are the well-known thing, and uh, I have not invented a pen. So how should I protect that intellectual property? Or I have put the different designs, the shapes in that. So what type of registration I should, or how should I protect that intellectual property? For that suggestion, it is highly recommended to go for an industrial designs, because these designs are different from the invented articles previously who has previously invented those articles. It is different because you have made the changes in the shape, and it is well known that people can modify such things. And if there are any lines or a patterns in the any design, that things can be protected. This is in this pen we are seeing that it is a three-dimensional and a two-dimensional article in the figure. If we take a three-dimensional thing, then we can easily understood that uh, it has a round shape, and it can easily write. And while seeing the two-dimensional features, we'll see there are different patterns that has been embossed in the design. So means my article is different, and this article should be protected under the design. In and if I have those designs, so nobody can use this article, or you cannot made or sell these articles. And apart from this, I want to tell you that in India, specifically in India, we had the Industrial Design Act, design law, in which that is protected. But in USA, they don't have an Industrial Design Act. So means they have a design patent. We have to file that application in a manner of a patent, and then we get that patent. But in India, we don't have a design patent. In USA, we have a design patent because they don't have a separate industrial design law. And the limitation of US is different, and in India it is different. So we don't have to confuse in all these things. It is a design or a patent or a design registration. It is the way of the country's law. In India, we had the specific law. That's why we cannot claim that it is a design patent. But in USA, they don't have that design law. Then they say that it is a design patent. Now, after the design, industrial design, we'll move to the trademarks. What is trademark? A trademark is a name, sign, symbol that is capable of distinguishing the goods or the services of one enterprise from those of other enterprise. A word or a combination of a words, letters, and the numerals can perfectly constitute a trademark. But trademark may also consist of drawings, symbols, three-dimensional features such as the shape and the packaging of goods, non-visible signs such as sounds or fragrances or color shades used as distinguishing features. The possibilities are almost limitless. The trademark registration will confer an exclusive right to the use of the registered trademark. This implies that a trademark can be exclusively used by its owner, or either it can be licensed to another party for the use in the return of for payment. The term of trademark registration can vary, but it is usually 10 years. It can be renewed indefinitely on a payment of additional fees. Now we have understood about the trademark. If we want to protect any name, then what type of intellectual property we need to file? We need to file a trademark application so that I can secure a right on that particular name, because I have not invented the name, and it cannot fall in the category of the patent. So then the name should be considered in the trademark, and you should go with a trademark registration. If I have a symbol, I have taken example of a McDonald's symbol. We recognize that it is a McDonald because they have the registration on this, and they always market this symbol on through their goods, what they are selling, the products they are selling, or the advertisement they are doing in the market. is under with the symbol they have created. If some if and they also have a trademark on "I'm loving it," means this is this is uh, a name that they have created, because if we eat the McDonald burger, then we always enjoy the taste. To protect such a jingle or a such sentence, then they have gone for a trademark registration, and these things helps them to secure their rights, to get the exclusive rights, and help us better to build a brand. That's why these slogans are all also being protected by the company. These are the various strategies how we can adopt to protect our intellectual property. Now we're gonna understand what is copyright. Copyright that creates have over their literary and artistic works, means the copyright are just the author rights who has created that literary work or that artistic work. What copyright covers? Copyright will cover the literary works such as novels, poems, plays, reference works, newspaper articles, computer programs, databases, films, musical composition, and a choreography. Artistic works such as painting, drawings, photographs, and sculpture, the arc and the architecture, advertisements, maps, and technical drawings. These are the works that the copyright law or the copyright covers. Means if we have these kinds of intellectual property, then we can go with the copyright registrations. Copyright, we have to understand how long the copyright registration is. The copyright lasts for 60 years in the case of original literary, dramatic, musical, and artistic works of the 60-year period is counted from the year following the death of the author. In in the case of cinematograph, films, sounds recording, photographs, works of the government, works of the international organization, the 60-year period is counted from the date of publication. Uh, Now we have understood the different, the copyright protection is granted for a limited time, but that how we gonna calculate that time? If I'm an author of any book, then my period will be counted after my death of 60 years. And in the case if the government has published or I have uh, created any film, my copyright will be last long for 60 years. After 60 years, anyone can use those copyright, and they don't have those infringements that you have infringed my copyright or not. To me, these are certain advantages and the disadvantages. If you are on the creator side, this will provide you a advantage and the edge over the competitor. If you want to copy that, it is a disadvantage for you, because these laws supports and this laws helps the creator to build their name and to get the recognition. We have in the intellectual property, we have understand about the recognition the creators get. Now we're gonna understand what is a trade secret. A trade secret is secrets are the intellectual property rights on a confidential information which may be sold or licensed. To qualify as a trade secret, the information must be commercially valuable before it is secret, be known only to a limited group of person, and be subject to a reasonable steps taken by a rightful holder of the information to keep it secret. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of the trade secret protection. Trade secrets can be protected. How we can protect the trade secret? It can be protected by taking the preventive measures against the theft or a misappropriation, including non-disclosure agreements, non-compete agreement (NCA), robust IP security infrastructure, controlling the accessibility of the important documents. In it, I just want to make it clear, you guys, that in India we don't have the specific trade secret laws. We have understood about the patents, design. They have the trade secret. They have the specific law under which we can protect. But in India, we don't have because our government don't want to promote the trade secrets because we understand that the trade secrets won't helps to share the knowledge. These are the knowledge that I've acquired, and I don't want to share with the society. And these trade secrets won't help the society to redevelop the things, to modify the things, and restrict the development of anything or any technology. That's why we have though we don't have a trade secret law, and that's why we don't want to promote the trade secrets in India. But some countries has a trade secret laws. Just take example, US has a trade secret law. In United States, we can go and protect our trade secrets, what we have generated uh, on generated by us. For example, Coca-Cola, we all understand Coca-Cola has not any patent on the mixture, what they are preparing, the syrup they are preparing. They have protected this recipe under the trade secret law. And by uh, it cannot be we have also understood that it cannot be just protect by filing and protecting. It has uh, it can only be protected through a preventive measures. If we are disclosing some information, then we can sign a non-disclosure agreement with a party, and then we understand that it can be protected. But it is not guarantee that your trade or you get a exclusive rights over that trade secret. Now we're gonna understand what is geographical indication. A geographical indication rights enable those who have the right to use the indication to prevent its use by a third party whose product does not conform to the applicable standards. For example, the Darjeeling tea. We know that Darjeeling is famous for tea. And if any tea that is grown, and if I am the owner and I am growing that tea in the Darjeeling, so I can use that name, the Darjeeling, for the tea. And it indicates that the tea has grown in the territory of Darjeeling, and these help to identify the goods, the origination of the goods, because there are many factors involved. The climatic condition of the Darjeeling is suitable for growing tea, and they have the plantation system. The stepwise plantation is required to grow the tea leaves. So therefore they have gone to and they have opt a indication, a geographical indication that we are famous for this, and we have adopted such things while growing the tea. So we need the geographical indication, and and it is not a individual person can use the geographical indication. It can be used by a community or a group of people, and the group of people can apply for the geographical indication. A protected geographical indication does not enable the holder to prevent someone from making a product using the same technique as those set out in the standards for that indication. Protection for a geographical indication is usually obtained by acquiring the right over the sign that constitute the indication. Means now we have understood I cannot restrict the person from using the technique that I have adopted. It can be used, but he cannot use my name as a Darjeeling tea. He can sell, prepare, he can use, but he cannot indicate that tea with a Darjeeling. That is the advantage that you have. And we know that in the Darjeeling tea is a very premium tea, and that is sold at a higher rates in the market. Geographical indication are typically used for agriculture products, foodstuff, wine and spirit, drinks, handicrafts, and industrial products. Now we have understood that geographical indication are given to which type of products? The agriculture products, the food stuff, the rasgulla, the Kangra tea, the Aligarh ke Tale is also there. People have applied, but they have not right now. It is in the application stage. They have gone for the geographical indication because Aligarh is also famous for its locks, the and spirits drinks that we have. We use the wines, handicrafts. Some handicrafts are there, and the industrial products that we are selling. And these products can be protected through GI also. Up now we're gonna uncover what is the plant variety protection. The plant variety protection provides legal protection of a plant variety to a breeder in the form of plant breeders' rights, PBRs. PBRs are the intellectual property rights that provide exclusive rights to a breeder of the registered variety. PBRs are used to protect new varieties of plants by giving exclusive commercial rights for 20 years. 25 years for trees or vines to market a new variety or its reproductive, reproductive material. Plant variety protection supports a long-term investment in breeding and provides a framework for investment in a delivery of seeds and other propagating material of the variety situated to farmers' needs. Now we have to understand, okay, if I have invented any seeds, we have understood that seeds cannot be protected under the Indian Patent Act. So, how we can protect those seeds? So, in that particular case, we need to go with a plant variety protection. In that, you get a protection and you have those exclusive commercial rights for the 20 years period, because this gives the farmers an advantage, and it is this act is made for the betterment of the farmers, because previously we had the Indian economy. We don't have many businesses. Our economy is mostly agricultural economy. So for the sake to protect the farmers uh, for the exploitation, because farmers are not too well educated, and they might not aware what the intellectual properties are, and to help the farmers, our government has implemented or come up with a Plant Variety Act. And now we understand another type called semiconductors, integrated circuits layout designs. A semiconductor layout design means a layout of a transistors and the other circuitry elements, and includes leads, wires, connecting such elements, and expressed in any manner in semiconductor integrated circuits. An integrated circuits layout design satisfy the following criteria and can be registered. If we fulfill those criteria, such as original, it should be distinct, capable of distinguishing from another layout design, have not been commercially exploited anywhere in India or in the convention country. When a company or an individual launches a new product with some unique feature, they can submit an application with the drawings, mask, and the layout of the circuit for registration. A period of 10 years counted from a date of filing of an application for registration or from the date of first commercial exploitation anywhere in India or in the convention country, whichever is earlier. Now we understand that a semiconductor has the different layouts, and we have restrictions. We cannot register those layouts in the design because our design does not allow these types, and it cannot be further protected. So the best method to protect this, we have a separate law under which we can go and file the application and solves our problem. These laws are there so that we can protect different intellectual property from the different laws, because patent law is for innovation. Name, there is a problem how we can protect the name of our product. Then another type of intellectual property was created, and we have the trademarks. And if we have just created another design, so in that particular manner we have the design acts. These are the laws that has been given or provided to by the government so that we can protect these intellectual property through various laws. And some have different advantages, some have another different advantages. And now these are the types of intellectual properties that we have. Now we'll be covering how to generate, uh, through a problem solving and the ideation, how the intellectual property can be created, because it is not so easy to create any intellectual property. We have to have a thinking, we have an understanding, so how we can generate those intellectual properties. It cannot be generated in a single day. It takes time, and it takes a time to mature, and then modify further modification and further development. Then the evolution of technology arises. First of all, I have given a figure. I have taken a figure of how the technology, how the problems that has come, and how we have solved those problems. Just take an example. In the previous days, we don't know how we can talk to a person through while solving that particular problem, how we can connect or communicate to a person who has a distance from my place. For that we have invented the phones, and later on it will turn from a mobile phone, because mobile phones give me the accessibility. Then I can move and talk. And then how the mobile phone first created, they were bulky in nature. Then after the modification, after the growing technology, after the maturing technology, now we had the smartphones. We can do anything in our smartphone. Even we can watch videos, we can do video chat or any type. It is all open and it is easy for our accessibility. For that we need just internet and we can do that. To reach to that level, we have come up with a big mobile phones. Then we have a small mobile phones with an antenna, so that they get some range. Then we have a small devices. And then the situation arises, to if we want to work in a specific field, then we have to identify the field. If we gonna identify that field, then it is easy for us to think and to get our brain and to identify the problem in that solution, eh, in that field. First, it is always just focus on one field. Don't focus on too many fields, because if you focus that too many fields, then it is difficult for you to develop anything or to create anything. So the best method, the best way is identify a field. In this field, I will be working, and what I'll be doing, what should be my way of working. I first identify the problem. How I can identify the problem? By seeing what challenging, what situation, what disadvantages I am having with this technology or with this device. Then only I can work on finding out that solution to provide the solution. And then I should know what should be the best method of solving that problems. This way I can easily generate a really good intellectual property. And in the mobile, you can also see in the mobile phones we have a different kind of intellectual property that is generated. Just take a example. First, we have a big mobile phone. It means we have done any modification in the systems, and we have generated a working way, a new working way. Then that thing can be protected under the patents law. We can file for innovation. And if we have also done some modification in the design or the aesthetic views or the ornamental shape of the mobile, then we can go for a design registration. And if we have to protect the name of that mobile, so we can go for a design, a trademark registration. And further, let's also understand that if we have done any modification in the circuits, so we have a design layout act under which we can protect that circuit or a layout. These are the methods that we can do, and we can generate a various intellectual property from a single product. And but to have those things, you have to focus on one field, then focus on the problem, then go for a solution and find out the best method of solving that particular problem. Then you get an idea, and then you can easily solve that problem. So best is to narrow down the field, to to identify that problem, and then you are ready to generate those intellectual property while while thinking. And for your knowledge, I want to tell you that if we want to qualify for a patent, then there are certain criteria that uh, we have to follow, and then only you will be getting uh, those registration. Take example, like if we have to file any patent, so it should be first, the novelty criteria is there, that the any I am the first person in the world who has come up with this idea or with this innovation. So this thing should be the first criteria to qualify for a patent. Second, the inventive step means it should not be non-obvious to a someone of a average skills who work in the field of your invention. Means if you are working as a software engineer, and if another software can understand that technology, and he can also pre- uh, made that technology but by just for small modification, then it is obvious to a person who is skilled in the art. So means you are not fulfilling that criteria of inventive steps. To that, you have to come up with an idea that should be unique. And if we combine the teachings of two or more people, then it should not be obvious. So that some drastic effect should be there in your patent application. And the it should further also have a industrial applicability. Eh, it should, your patent should be in used or manufactured in the industry, and should not fall under the section 3 and 4 of the Indian Patents Act. Because there are certain restrictions that are being given, under which if your patent application will fall in those criteria and in those sections, then you won't get the patent. Just take example of a section 4. Section 4 tells about the atomic energy related research. Means government of India don't want to promote such things. That's why they have restricted, and they that in that they don't allow patent, so that you have those exclusive rights, and it won't helps the society, uh, because people can misuse those things, and it won't be feasible for the society. Therefore, they have restricted such things, and you cannot go and to have a patent. Now, this all is from my end. If anybody has any question, please feel free to ask. I'll happy to answer all your questions.
Thank you so much, sir, for your wonderful words. Sir, I have some questions from students in my chat box. So I would
Yes.
like you to answer them and solve their problem. So first question is, what are the challenges of IPR?
There is no challenges such as in IPR. You have to understand what IPRs are there, and how you can protect your intellectual property. Means I have tell you, if you had the brand name, you go for trademark registration. If you had created any design, just go for design registration. And and then you will understand, and then you can easily identify which type of registration or which type of IPR protection you should go for.
Yes, sir. Sir, second question is, what happened when IPR is violated?
If IPR is violated, we have understood. First of all, we have understood IPR provides me the exclusive rights. If my IP is violated, then I can go for an infringement file an infringement suit against that person who has violated my IP. Or first step is to just tell them you are violating my IP. Just step down and don't use my IP because I have the registration. I have my registration taken and I have the exclusive right of using that IP. In that manner you can protect, and it is also on the enforcement how you are enforcing. If you don't want to enforce, it means if somebody is using and you don't want to stop, and you think that my money is I have to pump so much money to stop that, but ultimately he's using your IP and taking the benefit. You have to take a proper advices what strategies you should opt to restrict that person, and enforcement is a challenge. But in India we have a dedicated courts where you can go and fight with a person who has infringed your intellectual property.
Sir. So next question, how can I protect my IPR?
I have already discussed that how you can protect. There are different types of intellectual property, which IP, which category you fall, you should go and take a registration of that IP. If I have invented something, I should go for a patent. If I have created a new design, then I should go for design registration. If I have created a logo or a slogan that I should, if and I will be promoting that slogan, so I should go for trademark. If I have written any poem or a book, then I should go for a copyright, because these types of intellectual properties has defined which type of protection you will be getting, and different intellectual property has different rights and different criteria of ev- evaluation, because patents are evaluated on the different criteria, design will be evaluated on different criteria, copyright will be evaluated on different criteria, and trademark will be evaluated on different criteria. Means you have to understand which criteria you gonna fulfill, and based on that you should opt the strategy you should go for. If there are if I have made one phone and I know that the technology is well known, I have just done a cosmetic changes, then I should go for design, because it is not feasible and I won't get a patent because I'm not fulfilling that criteria. So it should be adopt or opt according to your requirement and what intellect you have, uh, what what intellect you have put, and you what result you have received. Based on the results, you can opt all these intellectual properties.
Thank you, sir. Now I would like to convey the vote of thanks. On behalf of our college, IMT College of Pharmacy, I extend our really hearty vote of thanks to our chief guest, Mr. Abhishek, sir, who spared time from his busiest schedule to grace the occasion. Today, we had an opportunity to hear your thoughts, and this will surely be going to encourage us in our future events. Your thoughts have enlightened our mind and have shown us a great path. And I will also like to extend my thanks to Ankita ma'am for the enormous support and coordination. Such an encouraging session. And last but not least, I would like to thank all the students for having this wonderful session with us. Thank you, sir, for joining us.
Thank you, ma'am.